How can a will be revoked? Have you ever wondered how a will can be canceled or made ineffective? Understanding this process is essential, especially for those preparing for the bar exam. Let's break down the ways a will can be revoked. One of the most common methods is through a subsequent writing. This means creating a new will that clearly states it revokes all prior wills. The new will completely replaces the old one. Alternatively, a codicil can be used. A codicil is a legal amendment to an existing will. It can revoke specific parts of the will or the entire document, as long as it has clear language showing that intent. Remember, both the new will and the codicil must follow state law formalities to be valid. Another way to revoke a will is through physical destruction. The testator, the person who made the will, can destroy the original document with the intent to revoke it. This destruction must be intentional and complete. Actions like tearing, burning, or shredding the will are valid methods. Just marking part of the will, like writing void on one page, may not be enough. It is also important to destroy all copies to avoid any confusion later. Revocation can also happen by operation of law. Certain life events can automatically revoke a will or parts of it. For example, getting married, divorced, or having a child can change or revoke a will's provisions. If the testator disposes of all property covered by the will during their lifetime, the will may also be considered revoked by operation of law. Additionally, revocation requires both intent and action. The testator must show a clear desire to revoke the will and take a physical action to do so. If the will is held by an attorney or another third party, the testator can instruct them to destroy it. However, this destruction must happen in the testator's presence to be effective. When creating a new will, it is wise to explicitly state that it revokes all previous wills and codicils. This helps prevent any ambiguity. If a will is not properly revoked, it can lead to disputes or costly litigation after the testator's death. Codicils can be useful for minor changes, but they may complicate the revocation process if not drafted carefully. In summary, a will can be revoked through a new writing, physical destruction, operation of law, or a combination of intent and action. Understanding these methods is key for anyone studying wills and trusts for the bar exam.